All right, what's going on, gun lovers? It's Rizzo. We back today with a story out of Ohio. All right, it's a groundbreaking story out of Ohio that's kind of turning heads in the self-defense community. All right, so it's about a guy named Tyler Wilson. I almost forgot to look at my teleprompter. Tyler Wilson. And it's about warning shots and self-defense. So we're going to look into a story that's kind of may redefine the rules of engagement. All right, so let's get to it. So, like I said, the story begins with a guy named Taylor Wilson, and he was convicted of felonious assault. I believe the story, he got into an altercation with another guy, and he fired a warning shot. All right, fired a warning shot. We've always been told that's not good, that's bad. But Wilson argued that it was self-defense. But during his trial, his attorneys kind of dropped the self-defense claim when the judge told him it was basically a non-starter. So that kind of led to his conviction, the warning shot, convicted. He was acquitted of the attempted murder charge, but he was convicted of felonious assault. So they weren't allowed to say it was self-defense, so he was convicted on that charge. So just reading from my notes, after his conviction, he appealed on the grounds of ineffective counsel, based on his attorney's decision to drop the self-defense claim. So ultimately, it arrived in the Ohio Supreme Court. Of course, it gets to the Supreme Court, and the question is, can a warning shot be considered self-defense? And according to the court, yes. It turns out a warning shot can be used for self-defense, according to Ohio Supreme Court. Everybody need to get a piece of this. All right, so according to them, the law doesn't demand an intent to harm or kill for self-defense claim. What is needed is the intent to repel or escape an attack. So what they were saying was that what he was trying to do was he shot a warning shot to let the guy know, hey, leave me alone. So then that, in effect, he was trying to prevent, repel, and escape that attack. So in their minds, that constitutes self-defense. I like this ruling. All right, so I'm going to read this. It says the state does not point to any language in the statute specifying that a defendant must have acted with an intent to harm or kill another person in order to assert and be entitled to a self-defense jury instruction. The statute requires only that the defendant use force against another person, and there is no further specification of the mental state required to assert self-defense. As there is no statutory support for the state's claim that a self-defense requires an intent to kill or maim, we turn next to case law. Case law specifies that intent necessary to assert self-defense. For nearly 100 years, this court has held that self-defense presumes intentional, willful use of force to repel force or escape force. This means that the use of force must be intentional, not accidental. The only additional intent required is the intent to repel or escape force, not an intent to use force to harm or kill another person. All right, so Wilson's his use of force was intentional. He admitted he grabbed the gun and firing it. He did not claim that he fired the weapon by accident or that the gun went off randomly. He testified that he fired the gun to escape or repel the other guy and to scare him off and back him off. So back to it. More recently, this court reiterated that a person may use deadly force in self-defense when he or she, one, was not at fault in creating the situation giving rise to the affray, and two, had a bona fide belief that he or she was in imminent danger of death or great bodily harm, and that his or her only means of escape from such danger was in the use of such force. And three, did not violate any duty to retreat or avoid the danger. Says our case law provides that the only requisite state of mind or intent that a defendant must have had to assert self-defense is that he or she intended to use force and that such force was used to repel or escape his or her attacker. Our case law do not require that any other state of mind, let alone an intent to kill or maim. So, as a result of that, his conviction was vacated. Good for you, Tyler. Good for you. They couldn't get a conviction on the first charge early, so it's up to them to try to retry him. But The only thing they had him for was for the firing the warning shot. So yeah. I love this ruling. So, this ruling it's a game changer. It's kind of depending if it stays. It emphasizes the intent behind the use of force and focuses on repelling or escaping danger and not necessarily on causing harm. Okay. So like I said, this conviction was vacated and now it's back to the drawing board for the prosecutors. All right. So I have said and will always say warning shots are just not practical anyway. If a threat is coming, you need to use your gun to excuse me. If a threat is coming, you need to use your gun to defend yourself against the threat, So from a practical standpoint, not very smart. But from a legal standpoint, it kind of makes sense, doesn't it? Let's be clear. From a practical standpoint, warning shots are still kind of risky. They can escalate a situation, giving your attacker a chance to strike back. So if you pull your gun, you really want to use it to stop the threat, not to warn or scare the threat. All right, but legally speaking, Ohio Supreme Court decision aligns with the fundamental principles of self-defense. So it's a good ruling. In Ohio, I'm pretty sure their legislature there is pretty pro 2A. So I don't think they're going to be trying to overturn this at all. All right, so I'm gonna just conclude. This isn't really about one man's legal battle. It's kind of about clarifying the rights of gun owners to defend themselves. So, like I said, while firing a warning shot may not be the best tactical choice, it's not a crime under these circumstances. All right, it's not a crime. It's kind of a reminder of the how complex self-defense laws are. And the importance of kind of understanding your rights and responsibilities. All right. So, what do you guys think about the ruling? Drop your thoughts below. Give me a like and a subscribe. Add on to my other 3 or 4 little fans, and let's get it going. Hit that bell button. All right. So, it's a new thing we're doing. Just kind of coming out with 2A news stories, trying to get them in under 5 minutes. So we'll come up with a name. It'll be named by the time you see it. Anyway. You guys stay safe, shoot straight, keep training. We'll talk to you later.